Freedom of Speech for Students, presented by Cheryl Jackson, Tanner Stevens, and Becky Davis. Today we will take an in-depth look at freedom of speech both on and off school campus. The issue of free speech on school campuses has been the focal point of controversy since the mid-20th century. The First Amendment grants students the right to free expression. This means students are allowed to speak, assemble to form groups, write articles, and petition school officials on issues of their concern. Although students in public schools do have freedom under the First Amendment, school officials still have court-ordered authority to decide which types of student expressions are acceptable. Student expression on campus is allowed only if it meets the following three guidelines. Number one, the student's expression of free speech must not cause a disruption to the school environment, nor may it prohibit the rights of others. Number two, the student's expression of free speech cannot be sexually vulgar or obscene in nature. Number three, the student's expression of free speech cannot contradict the basic educational mission of the school. School administrators have the right to take action against a student's behavior off campus only if the student's off-campus behavior connects to the school. The school administration is only allowed to intervene in a student's off-campus electronic freedom of speech if the behavior is believed to have the potential to cause a disruption on the school's campus. We will now explore some cases in which the issue of students' freedom of speech has been questioned and debated. Books in school libraries. 1982 was the first time the United States Supreme Court addressed the issue of books being removed from public school libraries. In the Board of Education of Island Trees versus Pico, the school district removed books from the shelves of junior high and high schools. These particular books were considered to be anti-American, anti-Christian, and anti-Semitic. Several students filed suit against the district citing violation of their First Amendment rights. The Supreme Court decided students have a right to have access to free choice discovery of knowledge. The school board was not allowed to remove books based on their own cultural or moral beliefs. Today, over 30 years after the Island Trees versus Pico case, there is still a large amount of controversy over which books should and should not be allowed in schools. In 2003, the Cedarville School Board in Cedarville, Arkansas, voted to require students to have their parents' permission before checking out books in the school's library. The book at the center of discussion during this time was the Harry Potter series. The popular series is filled with events of wizardry and magic. Christian fundamentalists in the district filed a lawsuit claiming their children's constitutional rights were being violated. They felt the books were a starting place for children to learn about witchcraft, sorcery, and other satanic ideas. District Judge Larry Hendren ruled the school board members had improperly restricted access to the books due to their shared belief that the books promoted a particular religion. The judge ordered the Cedarville School District to make the Harry Potter books available for general circulation in all public school libraries. In 2017, 7 students in a Denver, Colorado community committed suicide. As a result of this, a school district official ordered librarians to stop circulating the book 13 Reasons Why. This book, which has also become a popular Netflix series, follows a high school girl who commits suicide after she creates a series of tapes for her classmates to listen to after her death. The girl's message in the tapes provide information to each classmate about how they influenced her decision to take her own life. Several school librarians protested, citing censorship and violation of the First Amendment rights. The order to remove the book from library shelves was rescinded about 3 hours after it was ordered. As long as books are written, I believe there will be continuous arguments about what is appropriate and what is not. My advice to other educators is if you suspect a book you plan to read to your students may be a source of controversy, it is best to seek the approval of your principal.
So let's look at some court cases that affect symbolic freedom of speech or freedom of expression for students and for. So Tinker versus Des Moines is one of the most important cases when it comes to symbolic freedom of speech. Basically, students came on campus and they protested the Vietnam War by wearing black armbands. Many of them were from one family called the Tinkers. The school district took action against them and suspended them until January of 1966. The Tinker family filed suit. It went up to the Supreme Court.
After a series of appeals, the Tinker family had finally gotten to the Supreme Court where they ruled in a 7-2 ruling in favor of the Tinker family because the kids, while they were protesting the Vietnam War, they didn't cause any type of disruption at school. This has set a precedent for a lot of cases that have come after it. So what were the implications that were set by this case? Why does this case matter today? Well, there were two key precedents that were set by this case. The first being that it cleared up a lot of fogginess surrounding the First Amendment in regards to on-campus student expression. Now, because of this case, students are able to say what they want, act as they want, and wear what they want, so long as they're complying by school and district guidelines, like a dress code, for example. And that whatever they do, whatever they say, and whatever they wear doesn't cause a substantial school disruption, which we're calling the Tinker test now. In subsequent cases that have come after this ruling, schools and administrators alike were able to use the Tinker test to determine if something or an incident caused a substantial school disruption. And as we look forward to this next case, you'll see how the Tinker test was used. Now, after we've learned a little bit about the Tinker test, we can look at a contemporary example of how it was used. In the Fredericks v. Morse case, Joseph Frederick and a bunch of his classmates were able to go on a field trip to observe the passing of the torch. Now, they were in Alaska, and the torch was making its way down to Salt Lake City, Utah for the 2002 Winter Olympics. And while they were observing the passing of the torch, they decided to hold up a 14-foot banner that read, "Bong hits for Jesus," clear as day in front of all the people and all the cameras that were present. Now, when they were asked to take it down, the only person that said no was Joseph Frederick. He said that it was a violation of his free speech. He was then given a 10-day suspension. Morse was the principal at the time, and this is who Fredericks filed suit against. But she had the backing of her school district because of two district policies that she kept in mind when she was making up the suspension. The first being that students are not allowed to advocate the use of illegal drugs. Secondly, students will be held accountable the same way they are in the classroom as they will be on field trips. And these guiding principles helped her make up the suspension. And when Fredericks appealed in the court, in the lowest court, Morse had won. But then Fredericks reappealed to the Ninth Circuit Court, where Fredericks had won because they cited a lack of evidence and that something had to have constituted a substantial disruption to school. They used the Tinker test. But as we look forward to the Supreme Court ruling, we'll see what their interpretation of the Tinker test was.
Now let's look at the First Amendment for publications in districts. Basically, there's one case that regulates this for all schools. At Hazelwood School District, the school-sponsored newspaper, The Spectrum, was going to run two stories about teen pregnancy and divorce. This was in 1983. The principal, prior to the paper coming out, decided to pull these 2 stories from the paper before it was ran, and then Kathy Kohlmeyer and 2 other former Hazelwood East students brought the case to court. In the end, the court held that the First Amendment was not required for schools to promote certain types of freedom of speech, that schools are allowed to set high standards, and if a school-sponsored newspaper is inconsistent with the shared values of a civilized social order, they can censor that. The choice has to be made in reasonable relation to a legitimate pedagogical concern. So you can kind of decide to do things for educational reasons. So here's some contemporary questions about Hazelwood. So do students have First Amendment rights, and how did the Supreme Court's Hazelwood case affect them? Of course, students have First Amendment rights. Hazelwood ruling reduced, but it did not eliminate them. Basically, it just means that if it's school-sponsored, then the school district can limit pieces of it. The burden always remains on the school to furnish the legitimate educational reason for the censorship, and it cannot be just about protecting the school's PR. There has to be a legitimate reason behind it. Is Hazelwood always the rule for high school media? No. Some student publications are designated as forums. If they are, then intervention can only happen if the speech is unlawful or threatens to incite substantial disruption of the school day or something on campus. There are enhanced protections to student publications in some states, but Texas is not one of them. If a school can't censor the publication directly, can they censor it indirectly by pulling the funding or threatening the advisor? The thing is, no, they can't. They cannot punish or deter legally protected speech. That includes firing the advisor, cutting the budget, replacing the editor, or any other act of information, as long as it can be linked back to the editorial content of the publication. So they cannot punish people for what's being put in the paper. They can just censor it beforehand. Can the school censor what students write on blogs and other off-campus websites when they're on their own time? Most legal experts will say no, but a few recent federal court cases have opened the door for schools to punish speech that might lead to a disruption on school campus. Also, be very, very careful about joking around about hurting a student or hurting someone in a supervisory position at a school district. Things can go awry. Future implications. Basically, with the internet, there's a lot more complexity about figuring out what was done on campus, what was done off campus. Cyberbullying is a major problem. The question is it causing a disruption at school? Then the school district can get involved. And where does the school district draw the line? In conclusion, advice to teachers: use common sense. Think about the educational reasons when making a decision. So if you decide to censor something with your students, or you decide to read a certain book with your students, make sure you understand the educational reasons why you're doing something. Also, if something seems questionable, make sure to get approval in writing, or just flat out don't do it.